a boon or a bust for people, it's there. Speaking of which, anybody who's jumped on, please go ahead and acknowledge that you are being recorded. One of our ground rules, we do ask that everyone stays on mute except our guest, of course. We will have time for question and answers at the end, and we will call on you and ask you to unmute at that point in time. As far as our ground rules, the call, like we said, is recorded. Maintain professional tone when asking questions. Jim and I came up with this format from the very beginning. We've not had to censor anybody. We've not had to kick anybody out yet, but we threaten every time. If you don't watch your manners, you will be cut loose. So we throw that out each time. As far as news updates, next week, I do want to cover real quick that we will not be having a 1776 Syndicate weekly Zoom call because of primaries. That will be the day we expect everyone to get out and do their part, last minute ditch efforts and all that stuff. So there won't be one the following week. Correct me if I'm wrong, Jim, but I do believe we have State Superintendent of Public Instruction, Elsie Arnson, scheduled for the week following.
That's correct. And we're looking forward to having her on. Thank you.
Excellent, thanks. So again, moving forward, our guest tonight and an announcement, an updated announcement did go out to our members also, Professor Natelson. Based on your talk tonight, we will be having Rob talk to us about the background of Roe v. Wade, why it may be overturned, why the preliminary opinion was leaked, what the implications are for other established court decisions. And I assume also, if we get all that covered, and depending on where the line of questions go, I do hope you save some time at the end, Rob, for a little Article 5 overview, if you can squeeze that in. So with that being said, again, I've been following Mr. Natelson's career since he was a law professor at the University of Montana. Most people don't know this, but one summer I actually had, as a part-time job, I was the proofreader for Professor Ed McDonald. He did the Montana civil jury instructions for the state bar, and I had to proofread all the citations in that, and it was the most boring summer job I have ever had. So people in the law profession, I take my hat off to you. I couldn't get buried in that stuff for that kind of period of time. But I have been following Mr. Natelson's career for a long time. He's a nationally known constitutional scholar and author. His books, by the way, are on our membership site. His research into the history and legal meaning of the Constitution has been cited repeatedly by the United States Supreme Court, federal appeals courts, and state Supreme Courts, both by parties and by state and federal judges and justices. Mr. Natelson is widely acknowledged to be the country's leading active scholar on the Constitution's Article 5 amendment procedure, and among the leaders on several other topics as well. He was a law professor for 25 years, serving at 3 different universities. I know about the University of Montana, of course, and a senior advisor with the Convention of States Project. And I will say, Professor Natelson, that is the briefest biography I could come up with, because just about everything else is a full 2 pages with the accolades of your career. And I must say it's stellar. And we are really just blessed to have you on our call tonight. And I look forward to anything you can share with us. So with that being said, take it away.
Thank you, Rod, and I'm blessed to be with you tonight. It's good to see so many Montanans on this call, as a matter of fact. By the way, Rod, if you think you had a boring job, you need to compare it with the first summer job my daughter Rebecca ever had. She actually worked with me in the office of the University of Montana, typing Latin text from Justinian's Digest into format where we could post it on the internet. She had some good Latin background, and so it wasn't totally foreign to her, but it was a job of extraordinary tedium And she did very well because we subsequently published the results on the internet, the first ever usable internet collection of Justinian's entire codification of Roman law. But I'm not going to talk to you about that tonight. I'm going to talk to you about the background of Roe versus Wade, what Roe versus Wade teaches us, why it may be reversed, and what the possible implications of that are. The way I'm going to handle this is to point out various themes that run through the story of Roe versus Wade. And I'm going to do that because those themes have larger constitutional applications. In other words, as I touch on each theme, you should understand that it transcends Roe versus Wade. It actually is a motif that runs through our constitutional law and constitutional history. And if you keep these motifs in mind, then understanding modern constitutional law is a lot easier. The first theme is that the words of the Constitution are deeply rooted in history. They're also deeply rooted in law. Most of the founders were lawyers, practicing lawyers. And when I say founders, I mean both the framers who wrote the Constitution and also those people who explained it to the American public. And those founders who were not lawyers, like George Washington and James Madison, were nevertheless very well versed in law. So a lot of the expressions that sometimes people claim are vague or have no real meaning, or that the courts can pour content into them, actually had fairly precise meanings in the 18th century when they were inserted into the Constitution, and we have to, of course, recover them. One of those phrases is the phrase due process of law, due process of law. This phrase appears twice in the Constitution, not in the original documents, but in amendments. Both the Fifth Amendment and the 14th Amendment have due process clauses. The Fifth Amendment restricts the federal government and prevents the federal government from depriving any person of life, liberty, or property without due process of law. The 14th Amendment, which was adopted in 1868 after the Civil War was over, extended that protection to the states. The due process clause of the 14th Amendment says no state shall deprive any person of life, liberty, or property without due process of law. Well, you often hear people asking the question, what does that mean? I listened on YouTube the other day to a law professor from a California law school who basically tried to communicate that the phrase not depriving anyone of life, liberty, or property without due process of law was vague, or that the courts could pour their own content into it. That's not true at all. The phrase is in fact very, very old. A predecessor of it actually appears in Magna Carta, in the famous chapter 39 of Magna Carta, which says that the king will not go against anybody, will not prosecute anybody, except by judgment of that person's peers or by the law of the land. In 1354, that law of the land wording was adjusted in an English statute to say that the king will not prosecute anyone, and this means civilly or criminally, without due process of law. What it means basically is that if a state goes against you, either criminally or civilly, the state cannot make up the rules as it goes along. It can't it can't change the rules to the disadvantage of disfavored defendants. It must follow the established rules. It can establish new rules, but then it must apply those new rules only prospectively. So there's really no serious question as to what the due process clause means. But there's a second theme, the first theme, of course, being that these phrases are well rooted in history. The second theme I'm going to mention tonight is one that I call the Great Forgetting, the Great Forgetting. And it's something that happened mostly during the 19th century. During the 19th century, people tended to forget the Anglo-American basis of law in the United States. Americans quite naturally wanted their own domestic law. Treatises were written on American law to separate it from English law. And this was basically a healthy development. But one of the costs of it is that people forgot the meaning of a lot of these specialized phrases that the founders, who were heavily rooted in English law, had inserted back in the Constitution. And one of them was due process. Some people started thinking that due process meant that if the court thought that a law interfered with liberty too much, that it could strike down the law. Now, in the original due process clause, not depriving somebody of liberty simply means you don't lock him up without following established procedures. But the idea came about that, well, maybe the court can start regulating state legislation or federal legislation to limit how much it can limit liberty. The first use of this, or misuse of the due process clause, actually arose in 1857 in one of the most notorious cases in the Supreme Court's history, and that is Dred Scott versus Sanford, the case which held, against all the founding era evidence, that an African American could never become an American citizen. And in that case, Chief Justice Taney said, the Congress cannot ban slavery from the territories, because if a slave owner takes his slave from a slave state into a purportedly free state and loses that slave, that would deprive that owner of property without due process of law. That, of course, is not what the clause means, but in subsequent years, the Supreme Court picked up on this theory that the court can start reviewing state and federal laws to make sure that they didn't limit liberty too much. Conservative courts started to do this early in the 20th century. They struck down state laws that they thought interfered too much with parental rights. They struck down state and federal laws that they thought interfered too much with free enterprise. And then later on in the 20th century, liberal courts repudiated most of those decisions, but started to strike down laws that they thought interfered too much with the liberal social agenda. And one of those was the abortion decision of Roe versus Wade. So this kind of brings up the third theme, which is, if you misinterpret the Constitution in a way that gives discretion to the justices that they're not supposed to have, then your decisions will bounce back and forth according to the political makeup of the court. Obviously, that's not something that could happen, that should happen. We recognize it will inevitably happen around the margins, but if you start misinterpreting the Constitution and creating new meanings for the clause, then you're going to have that problem, not just around the edges, not just the margins, but over and over again. And that's what happened with the due process clause. A pro-slavery court struck down a law because it thought it violated due process. Conservative courts struck down laws that they deemed to be free enterprise, anti-free enterprise, and then liberal courts started striking down laws that interfered with the liberal social agenda. The fourth theme I want to mention is that the Supreme Court, in interpreting the Constitution, is sensitive to criticism. Rod mentioned earlier on Article 5, the amendment process, which we probably won't have much time to discuss. But one of the points I make when I talk about that is that back in 1795, we passed a constitutional amendment, the 11th Amendment, to reverse a Supreme Court opinion, and the Supreme Court's never gotten over that. I mean, they are extremely sensitive to that kind of to that kind of response or that kind of criticism. And the criticism that came up with their new interpretation of due process was, look, if you, the court, think you can strike down any law because you think it interferes with liberty too much, then what are the limits? I mean, what kind of principle are you going to apply here so that the court just doesn't invalidate any law it doesn't like. And so the court began in the 1960s to enunciate a principle. And here is their language. They said they would only protect liberties that were deeply rooted in this nation's history and tradition. Deeply rooted in this nation's history and tradition, and implicit in the concept of ordered liberty. Now, that sounds pretty vague, and I think to a certain extent it is, but let me give you a good example. A recent Supreme Court case called Ramos versus Louisiana, decided just 2 years ago by the US Supreme Court. The opinion was written by Justice Neil Gorsuch. Louisiana had a law which said that we will allow a criminal defendant to be convicted of a crime by a jury if the jury, even if the jury is not unanimous. If a jury votes, I think it was 10-2 for conviction, that will be sufficient. That Louisiana law was reversed by the Supreme Court, and Justice Gorsuch went into the history of trial by jury to demonstrate that the idea that a jury must be unanimous to convict in a criminal case is deeply rooted in our tradition. That's what was understood by at the founding. That had been understood for hundreds of years before the founding, and it was widely understood after the founding. So in that instance, he said that particular Louisiana law deprived the criminal defendant of liberty without due process of law. Now, I don't think that's necessarily an accurate reading of the Constitution, but that's an example of what the court means when it talks about a right deeply rooted in our traditions. Well, when Roe versus Wade was being considered in 1973, the question arose is a right to abortion deeply rooted in our history and traditions? And Justice Blackmun, who wrote the opinion for the majority, said, yes, it is. And his evidence was that he said that abortion was not made a crime at common law unless the abortion was performed after quickening, that meaning during the third trimester, but that during the first 2 trimesters, the common law protected a right of a woman to abort her child. And secondly, he said that the states permitted women to have abortions, and they continued to allow women to have abortions right up to 1868 when the 14th Amendment was ratified. And so the idea that women should not abort earlier than the 3rd trimester, he said, was a fairly late development in American law. And therefore, he believed the Constitution and the 14th Amendment did protect this right that was deeply rooted in American tradition. Well, this leads me to the next theme, which is that judges and law professors are really lousy historians. I have training in history, and as somebody who's been trained in history, I read some of the things that are written under the guise of history by law professors and judges, and I have to smile. Justice Blackmun's history, that is to say, his claim that the common law and the states before 1868 permitted abortion, was in fact inaccurate. What Justice Blackmun did is he borrowed from the writings of a law professor at a 4th-rate law school. The law professor's name was Cyril Means. He was an abortion activist, and he claimed that abortion was deeply rooted in the American tradition. In fact, that was not true. It was an egregious mistake that commentators began to point out almost immediately after Roe versus Wade was decided. So when Justice Alito wrote his draft opinion, the one that's been leaked, he actually, if you look at the opinion, he actually includes at the end of it an appendix with 30 pages of state anti-abortion statutes adopted almost all before 1868. So the fact is that the historical judgment of courts and of lawyers and of law professors, even of the US Supreme Court, is not always necessarily to be trusted. This is one of the reasons it's so important for those of us who do have training in history to submit friend of the court briefs to the court when cases come up involving historical issues. The last point I wanted to make, which is a theme that runs through American law, is that when courts do overreach themselves, as the court did in Roe versus Wade. And by the way, let me say parenthetically, this is not about whether you are in favor or against abortion. Many pro-choice scholars have severely questioned and criticized Roe versus Wade. Ruth Bader Ginsburg, who believed in some federal constitutional protection for abortion, herself criticized Roe versus Wade as going way too far. And so this is a broad bipartisan criticism of this decision. So when courts do go overboard, especially when the Supreme Court does, you get certain serious consequences. One is you get a reduction of respect for the law. You also get a situation where the court's decision often doesn't fit with the rest of the law, and the court has to spend time in later cases logic chopping in order to distinguish the mistaken case from the case at hand. And you, in many cases, create severe divisiveness among the American people because opponents of the decision recognize that it's overreaching, recognize that it's not well-based, and you get bitter conflicts over it. I'll revert for a minute to the 1857 decision of Dred Scott versus Sanford, where the Supreme Court way overreached itself by saying that African Americans could never be citizens and Congress could not ban slavery in the territories. The court itself thought it was putting an end to that issue. What the court did instead was help bring on the Civil War. And there are other examples like this in American history. And certainly Roe versus Wade is one of them. The vicious nomination fights that we see in Congress almost every time the president nominates a Supreme Court nominee, the severe divisiveness we have 50 years after Roe versus Wade was decided over this issue of abortion is largely the product of the court's decision in Roe versus Wade and its refusal to let the democratic process play out so that the abortion issue could be resolved that way. Let me just finish up by saying what Justice Alito emphasizes in his opinion, and maybe speculate as to the reason why that opinion was leaked. It's been disappointing to see the media treatment of this draft opinion because there's been almost no discussion of the basis for Justice Alito's decision or his potential decision. But one point he makes is that, and it's a central one, is that the history that Roe versus Wade relied upon for demonstrating that the abortion liberty was deeply involved in our tradition was in fact faulty. It was simply untrue. And so the main underpinning of the case has been lost. Secondly, he mentioned the cost of the decision. The cost first in the necessity of the court to adjust its other doctrines, its other cases in odd ways in order to accommodate a rogue decision, and also the severe divisiveness that the decision has caused. If in fact this does become the ruling of the court, then abortion doesn't end in America. What happens is the matter goes back to the states. There will be states that will pass pro-choice laws. There will be states that pass pro-life laws, and there will be states that will find ways to compromise and adjust the differences. And that's really how our federal system is designed to operate. Why was this opinion leaked? This is something, as you probably read, which has virtually happened never before in our country's history. Let me give you an example of a precedent from, well, from the great state of Montana. In 1972, a Montana Constitutional Convention proposed a new constitution to the voters of the state. The Constitution was controversial, and the election on the Constitution was exceedingly close. There were, when the dust cleared, more yes votes than there were no votes by a tiny margin. On the other hand, it was also clear that the Constitution had not passed the required ratification threshold of a majority, not just of the yes or no votes, but a majority of all those people who had participated in the election. Many people had been told, if you don't vote on the Constitution, it's a no vote, because the Constitution must win a majority of everyone participating in the election. Nevertheless, the governor, Forrest Anderson, a great advocate of the Constitution, declared that it had been adopted. And naturally, a lawsuit was begun against it. The Montana Supreme Court assumed original jurisdiction. After hearing oral argument, the Montana Supreme Court met in chambers secretly, and the 5 justices of the court voted, and they split 3-2. The majority holding that the Constitution had not been properly adopted. Somehow the words of that, the word of that vote leaked out, not to the general public, but to powerful Montana political figures, including in all probability, Senator Lee Metcalf. Pressure was apparently applied to the justice who was deemed to be the weak link to get that justice to change his vote. Most people think it was Justice John Harrison, but we don't absolutely know. At any rate, for some reason, almost certainly due to this political pressure, the justice did change his vote, resulting in the vote, instead of being 3-2 against the Constitution, becoming 3-2 in favor of the Constitution. Whoever leaked this particular Alito decision or abortion decision probably was, as Professor Dershowitz has speculated, a law clerk, meaning a former law student who's serving for a year as a justice's assistant, a former law clerk for one of the liberal justices. Our Supreme Courts, our law schools are very liberal, and most of our graduating law students are very liberal. And perhaps that justice thought, even if he didn't know about the Montana precedent, that there would be a public outcry, and that pressure could be brought to bear on one or more of the justices to get him or her to change his or her vote. Which justice? I think most likely Justice Kavanaugh, because Justice Kavanaugh was obviously emotionally hurt by the nomination proceedings he had to go through, by the tenor of those proceedings. He's someone with deep roots in Washington, D.C., who would naturally think seriously about what people in the Beltway thought about him. So that's my hypothesis. I realize there are other hypotheses out there. Part of it was to galvanize the Democratic base. Maybe so, but it was going to come out this month anyway, and you could have galvanized the Democratic base then. I think it was an attempt to effectively corrupt the court in the same way that the Montana Supreme Court had been corrupted by political pressure 50 years earlier. I'd be happy to take whatever questions you might have.
I have a quick one for you just on, well, I've got several actually. Thank you, Professor Rob. The first is, do you think it was a justice then or a clerk that leaked this?
I think it was a clerk.
It was a clerk. Do you think that the justice knew that?
I think probably the justice did not know. Remember, the justices serve for life,
Right.
or at least until retirement. So they have a very heavy stake in maintaining good relationships with their colleagues. So I think, and furthermore, these justices are all seasoned professionals. I think it highly unlikely that a justice either licensed this or knew about it. Clerks, on the other hand, serve for 1 year. As I mentioned, many of them are ideologically liberal, especially those who would work for liberal justice. Our law schools these days are basically echo chambers. So it's very easy to get self-righteous about thinking that your political views are the only ones that matter. And a clerk would be in a position to do it. I want to make clear that someone referred to these as lowly clerks. These are not lowly clerks. These are highly intelligent, recent law graduates who are headed to very top jobs in law and in legal academia. Now, this particular clerk, once his or her identity is known, and it will be known, is going to suffer from this professionally, perhaps, in one sense. But on the other hand, this clerk may have calculated, probably accurately, that there are hundreds of thousands of dollars of speaking fees available at universities throughout the country as universities celebrate the courage of this person in releasing the decision that could potentially overturn Roe versus Wade.
Wow, that's it's very intriguing and disturbing at the same time. I have another question. You had referred earlier to friend of the court briefs, amicus briefs, I believe. So is that something that only scholars, legal scholars, attorneys can do, or is that something politicians can also do, or attorney AGs, that sort of thing? I guess, this is more of a erase my ignorance for a second. How does that process work? How do you influence the court?
Friend of the court briefs, or the original Latin expression is amicus curiae briefs, are briefs that are submitted to the court by non-parties in order to help the court make a decision. In very important cases, generally all the parties agree to an unlimited submission of amicus curiae briefs. And they don't have to come from attorneys general or lawyers. They can come really from anyone. But the amicus briefs that are given consideration are the ones that A, have something to say, by B, someone who has some expertise to say it. So an amicus brief that simply railed against abortion and claimed abortion was murder probably would not be given serious consideration by the court. But an amicus brief that maybe corrected some technical errors in Roe versus Wade, written by someone who knows what he or she is talking about, probably would be given very serious consideration by the court. Let me give you a good example from my personal experience. After I left the University of Montana and came back to Colorado to work with the Independence Institute, the Obamacare case was coming up before the United States Supreme Court. And a lot of people don't recognize there actually were 4 issues in the Obamacare case, not 1, but 4 issues that dealt with the mandate, Congress's mandate that people buy health insurance. First was the argument that mandate violated the Commerce Clause of the Constitution. Secondly, that it violated the Necessary and Proper Clause. Thirdly, that the mandate was tax. And then fourthly, that the Medicare extension, the requirement that states expand Medicaid, that the Medicaid extension was unconstitutional. And as this proceeded, I said to my friend and colleague at the Independence Institute, Dave Kopel, Dave, I see a lot of argument about the Commerce Clause. I see a lot of argument in these briefs about, I see some of it on the tax clause, but I don't see anything on the Necessary and Proper Clause, or not very much. And I just wrote a book on the Necessary and Proper Clause. And I don't see anything on whether the Medicaid extension is proper under principles of federalism. And so we submitted 2 amicus briefs. One amicus brief argued that the individual mandate violated the necessary and proper clause. In Justice Roberts' opinion, he followed our brief extensively, although in that particular instance, he didn't mention the name of the brief, but he followed it extensively. And then secondly, on the Medicaid extension, we won 7-2. And I think that was a result of our brief, because before that time, the challengers to Obamacare had given that issue up as a lost cause. So amicus briefs really can have a significant impact. Much more recently, I'll mention this and then quit this rather long answer. When last year, when the Supreme Court heard the case of Espinoza versus Montana Department of Revenue, the issue was whether Montana's so-called Blaine Amendment violated the U.S. Constitution. We at the Independence Institute submitted an amicus brief arguing that, as I have for decades, that yes, Montana's Blaine Amendment did violate the U.S. Constitution. And our argument was cited explicitly, including my article on the subject by name by Justice Alito. So I cite these as personal examples because they're personal testimonies as to how important.
Thank you. I do have more questions. I'm going to default or defer actually to Representative Fuller. John, can you go ahead and unmute and ask your question? Thank you.
Yeah, Dr. Natelson, I'd be interested in your opinion. It is my understanding that the leaked opinion regarding the Roe v. Wade is amicable to overturning Roe v. Wade based on the idea of a reassertion of federalism, in that the Roe v. Wade was not good law in that respect. I'd be interested, and I would be more interested personally, if the argument against Roe v. Wade was based on the 14th Amendment and the deprivation of rights of due process to the person, sometimes known as a fetus. Could you elaborate on that? Was my assumption correct in regarding the brief synopsis of the leak that I read?
Yeah, first off, Representative Fuller, it's good, very good to see you again.
Thank you.
Secondly, yes, federalism certainly plays a role in Justice Alito's draft opinion. Now, the 14th Amendment due process clause is in some ways an anti-federalism rule. It's a national rule designed to prevent states from abusing their citizens. However, when that rule and the other rules of the 14th Amendment of the Constitution don't apply, then we default to federalism. And we allow the states to work these issues out by themselves. Now, there is a school of thought among pro-life people, and in fact, there's been a little bit of a resuscitation of the school of thought among scholars, that an unborn child is a person, and therefore for the state to deny protection to an unborn child or to water down protection from an unborn child is in fact a violation of due process. Just as, for example, if the state said, you know, from now on, we're not going to protect the rights of Asian Americans. You know, let them fend for themselves. That would be a violation, I think, of the due process clause. And so the argument would be that this is a similar violation of the due process clause. I think that argument, however appealing that argument may be to pro-life people, including myself, I think that argument is a constitutional stretch. And the reason I say that is because the word person had a fairly clear meaning, both when the Constitution was adopted and the 14th Amendment was adopted. The word person referred generally to someone who was born. Now, that didn't mean that the fetus had no rights at all. The fetus did have rights and was, as I mentioned earlier, protected by state law. But for constitutional purposes, it would be a very heavy lift to argue that the constitutional term person includes unborn persons. Maybe someday that decision will be made, but I suspect that we're going to have to let the forces of federalism work in the interim.
As a follow-up to that, and John, I see your hand is still up, and it sounds like you've got a follow-up as well, but I'm going to jump in here real quick. At what point do you think, or would it ever happen, Dr. Natelson, where new scientific development revelation, would that ever override deeply rooted common law? I mean, could a case be made for that, just with new understanding trumping old understanding?
That's a very good question, Rod. And I would say that the answer is a very definite affirmative maybe.
Perfect.
The Constitution does, in many cases, accommodate new technologies. Let me give you a good example. There are people who argue that the Second Amendment protects the right to keep and bear arms, but the only arms that it protects are muskets and other weapons that were in existence at the time of the framing. Well, that's not really a credible constitutional argument, because the amendment doesn't say arms as they exist at the framing, it says arms. And we know from the history of the amendment, this means arms that can be borne, portable arms, and those that are used in military and self-defense purposes. So that's broad enough to include, for example, an AR-15. Even though AR-15s didn't exist in 1791 when the Second Amendment was adopted. I suppose there might be a constitutional purist who would say the power that the Constitution gives to Congress to regulate commerce among the states only applies to forms of commerce that existed when the Constitution was adopted in 1789. So Congress may regulate barges, stagecoaches, wagons, and horse travel, but not airplanes, cars, trains, and so forth. Well, that's not a good reading of the Constitution, again, because the word commerce is designed to accommodate those additional developments. By the way, this actually brings up another theme which I didn't mention. There is a common claim that the Constitution is kind of a horse and buggy document that cannot accommodate new developments. These are two examples where it can. The problem, and so it's possible to make that argument that an unborn fetus is a person as a matter of having a number of chromosomes, having a existence largely separate from the mother, having his or her own heart, and so forth. It's very possible to make that argument. I think that would be a difficult argument to make because the definition of person, I think, was more specific as it was understood when the Constitution and the 14th Amendment were adopted. I think there was a specific understanding that a person did not include an unborn person, that unborn people were given protection as a matter of legislative grace rather than as a matter of divine right.
John, I'll let you go ahead. Did you have a follow-up question?
I did. So I understand your argument there regarding at the national level on the US Constitution regarding the 14th Amendment, which, by the way, you have just shot completely out from underneath me. One of the things that I've been relying on in my pro-life arguments to people, but I understand your position. So then as a practical reality then, for those of us here in Montana, when if Roe v. Wade is overturned, as it appears it's going to be, or a practical reality here in the state of Montana, then we will going to have to, for those of us who wish to believe as such, going to have to insist on a constitutional amendment for the Montana Constitution, or as Dr. Annie calls it, the personhood amendment. Is that what you are advocating would probably be necessary?
Well, if you read the background of the Montana Constitution and the debates over the Montana Constitution, it's very clear that those people who wrote it and ratified it intended abortion to be a legislative decision. They intended the state neither to take they intended the Constitution neither to take a pro-life nor a pro-choice stance, that was a matter for the legislature. The Montana Supreme Court, in the Armstrong decision, has staked out an extreme pro-abortion position. And I think there's a high probability that if Roe versus Wade is overturned, then pro-abortion groups will bring a lawsuit in the Montana Supreme Court against any legislation you folks in Helena may pass, and that the court is likely to strike it down. In fact, given the extreme record of the Montana Supreme Court, I don't know if there's anyone on this call who's not from Montana, but it's worth emphasizing that the Montana Supreme Court is a real outlier among state Supreme Courts. I mean, the normal curve of courts is something like this, and then the Montana Supreme Court sort of like this, you know. It's out in Pluto, out where Pluto is. And it's very likely to take the position that that abortion is permitted at all stages of pregnancy as a matter of right in Montana. And what that means is, yeah, you're probably going to need a constitutional amendment.
Well, then I'll have a follow-up question. What do you think if that were to happen? Not just, let's take it outside of Montana. We've got 50 whole states. And some of these states probably will pass personhood amendments. So is this going to end up being back at the United States Supreme Court, in your opinion?
I think it's most likely to be at the United States Supreme Court if there's a significant change in personnel of the court. The fact that this draft opinion was not written by Chief Justice Roberts, as it normally would be if he were in a majority, tells me that it's a 5-4 decision. And that means if, let's say, God forbid, Justice Thomas or Justice Alito were to keel over tomorrow, and Joe Biden were to appoint 2 justices, pro-choice justices to the court, yeah, then it's very likely that somebody will be back at the court saying, recognize the right of abortion. I don't know if a court would completely reinstate Roe versus Wade, because I think that, as I mentioned, even many pro-choice people have real doubts about how far the court went in Roe. But I certainly think you can foresee litigants claiming that to restrict abortion entirely violates another part of the 14th Amendment, the Equal Protection Clause. No state should deprive any person of equal protection of the laws. And this is an argument, in fact, that Ruth Bader Ginsburg made, that complete bans on abortion have the effect of denying women equal protection. So if there is a change of personnel on the court, yeah, I think you could see the abortion issue is coming back.
Anybody else? Go ahead and raise your hand down in the reactions mode, or I believe that's where it in there. Or just raise your hand if your video is on, and we'll call on you. Otherwise, I and the good retired teacher are going to keep going here.
Yeah, Rob, I have a question for you. Thank you for your experience and your expertise. And I think my IQ level, my own personal opinion, just dropped a couple notches listening to you. So thank you for your knowledge tonight. You know,
I mean, I brought it down.
Yeah, you brought it down. Well,
Well, we used to make a joke. Let's see how it went. I briefly had an academic appointment in Oklahoma, and the joke was that the 50,000 smartest people in Oklahoma were going to be moving to Texas, thereby, see how did this work? 50,000 smartest people were going to be moving to Texas, thereby lowering the collective IQ of both states.
Well, in other words, I know less than I thought I knew until tonight's call. So thank you for that. My question for you specifically around this case is, as a nation with everything going on, can we handle the outcome of this court case? In other words, are we going to see disruption in the streets to a degree that this nation can't handle the outcome of this? Because as you know, the media has turned everything small into something big, and this is certainly something big that could even be larger.
Yeah. Yeah, there may very well be civil disorders as a result of the case. I mean, we've had massive civil disorders caused ever since the late 1960s, almost invariably brought on by the left, the big exception being on January 6, 2021, but otherwise almost invariably brought on the left for causes that are less cosmic than this. On the other hand, looking to the long view, what's the future of the country if Roe versus Wade is not overruled versus the future of the country if Roe versus Wade is overruled? If Roe versus Wade remains in effect, then the kind of division that we've been seeing goes on and on and on and on in perpetuity. More and more nomination proceedings become poisoned. More and more attacks by national organizations with stakes in the abortion issues, muddying congressional elections and other decisions. If this is overruled and the courts, if Roe versus Wade is overruled and that decision sticks, then the matter comes out of Washington, D.C. and goes into the state capitals. It becomes much more difficult in those circumstances for activists to make a national issue of this. And the debates become caged by states. And then hopefully in some states, compromises are worked out, which nobody likes, but everybody can live with. I think this might be, one of the major things that could lower the temperature in this country. So, and I think that the majority of the Supreme Court understands this. I mean, reading between the lines of Justice Alito's opinion, I think they understand that.
Thanks for that question, Jim, because I think the response is something we all needed to hear. You know, it's, again, we all believe that, you know, less federal control, more state control is the answer to just about everything. And looking at it in that light, I was more on the negative side. I was looking at, one of my questions was, do you think this could have been leaked just to create more divisiveness? And I guess that question's still relevant. And do you have an opinion on that?
I think it was leaked to create controversy. I'm trying to put myself in the mind of the highly intelligent young person who probably was responsible for this leak. And I think what was in the mind was that, yeah, there's going to be controversy, but the pro-choice people are going to be able to outgun the pro-life people in this, and they will force, and Justice Kavanaugh will feel forced to back off. I don't think that's necessarily an accurate perception. I think the person might have misjudged Justice Kavanaugh, but I think that's the long shot this person was taking. You know, the people who are involved in this issue really don't care that much about the divisiveness, right? I mean, the people who are pro-life believe that's what's going on is mass murder, or at least mass manslaughter. And ending that is more important than dealing with than toning down divisiveness. And the people on the other side believe that regulations of abortion are frontal attacks on a woman's personhood and her right to control her future. And defending that fundamental right that a woman has, well, that's worth a certain amount of divisiveness. You know, dealing with divisiveness is sort of everybody's second favorite issue. It's like states' rights or federalism. It's where people say, you know, well, I'm normally in favor of states' rights, or I'm normally in favor of federalism, but this issue is too important. This has to be determined nationally. You hear that all the time. It's everybody's second favorite issue. Well, dealing with divisiveness is everybody's third favorite issue, I should say. You know, everybody's against divisiveness, but they've got other issues that are important enough to make them tolerate the divisiveness.
Thank you. And I know that was kind of a loaded question. We've just got a few more minutes here, and I do want to be concerned with everyone's time and be professional about this. But if anyone wants to stay on this call a few minutes after, I'll certainly do it. But Mr. Fuller, you have another question. Let's see if we can squeeze it in a couple of minutes.
Thank you, Rod. Dr. Natelson, one last question. And obviously, here in Montana, then, what we have gotten then is if Roe v. Wade is overturned by this court and it goes back to the states, which makes it an issue of states, which is where it should be. However, for those of us involved in the state of Montana, this is going to be an incredibly acrimonious and incredibly divisive and all out, no holds barred struggle over the future of not only the court of Montana, but also the future of abortion in this state. And this is one of those issues like slavery for which there is no compromise for many of the participants, because it's a more moral issue, and moral issues have difficulty. It's either a killing of a person or it is not, and for many individuals, and probably a majority of individuals in Montana. So what do you predict with your objective, your ability to be a lawyer objective, the future holds for Montana over the next 4 or 5 years over this?
Well, Representative Fuller, I've been out of Montana politics for a long time. And so you're probably more qualified to deal with that than I am. I think that you're right. It's going to be divisive. It's going to be rough. I think that the Montana Supreme Court, assuming it sticks to its Armstrong position, is going to be creating some additional political problems for itself. I'll be honest, I think that's good. I think that the Montana Supreme Court has been a problem for a very long time. I started publicizing the court's truly erratic series of decisions back in 2002, and I'm glad to see that Montanans are beginning to address this issue. And so, yeah, it's going to if the court comes down on one extreme of the abortion debate and says, you know, abortion is a constitutional right in Montana right up to the time of birth, I really don't think most Montanans, even most pro-choice Montanans, are going to accept that. And they're not going to accept that the court is dictating that, as opposed to them making the decision for themselves. So I would foresee that would cause additional controversy regarding the court. It's also going to cause additional controversy for you guys in the legislature. And all I can say is, I'm glad I don't have your job. I'm glad I don't have your job right now.
Thank you very much. You know, I have to say, Professor Natelson, your ability to literally walk through this and show us what life can be and probably will be like on both extremes. You should have been in politics. You know, you've got this well-balanced wisdom that just kind of cuts through. And
well,
you know,
Rod,
I want to thank you for
Rod,
sharing that with us.
Rod, with all due modesty and respect, I should have been governor.
Yes, you should have. I agree. I did my part. Maybe not enough.
And in fact, we actually did very well in 2000 because, as you know, in Montana primaries, you can pick up whichever ballot you want to vote in either ticket. And there were 5 people on the ballot. The other 4 were all statewide office holders. And I came in second among the 5 to the person who then went on to become governor. So if I sometimes think of, gee, what if, that I am also gratified by the expression of trust that so many Montanans expressed.
Well, I will say that you have still been in public service. Everything that you're doing, it has been in the
Yeah.
service of
I
our
appreciate that.
great government.
Thank you.
And we recognize that, which is why we wanted you to be a guest on this show. And we truly, truly appreciate your time, your insight, your wisdom on these issues. And I think we all come away with it from it with a little bit different perspective. And maybe that's going to be part of what we need to heal the divisiveness that's out there. So we're actually over time. I want to thank you again, most deeply, Professor Natelson. Thank you. I appreciate you. I respect you and what you're doing, and carry on the good fight. And maybe we'll be able to meet here again.
Thank you. It was a privilege.
Thank you. And for the rest of you, again, no call next week. The week following will be a good one with Elsie Arnson, our state superintendent of public instruction. So that'll be good after the primaries. Thank you all again, and have a very good evening.